My name is Kimberley Morris. I'm from Colorado Springs, Colorado, and I'm a victim of family court corruption. Through the incompetence, dereliction of duty, and corruption of the court, and those acting as officers of the court, my children were forced to withstand 4 years of abuse in their father's care, and I was legally prevented from protecting them. Before I could file for divorce, my ex moved his paycheck to an account I could not access, leaving us without food or gas money. He refused to pay for car repairs and payments in an attempt to get my car taken from me. He approached the psych ward at the hospital to try to get me committed, even though I've never had any mental illness or mental dysfunction in my life. He secretly schemed with his family to take our children out of state and relocate them without me. He arranged for the military to pick up and move our household goods right from underneath me. I could not qualify for welfare as their office considered his income mine, even though I had no access to it. Even after filing for divorce, the only food I could get for months was from the Mormon food pantry. After my ex was finally ordered to pay me support, he then and only then filed for sole custody of the children based on psychological evaluation of me. He claimed I had mental problems when he knew what I really had was a rare neurological condition. All of this information was made available to each of the mental health professionals on my case, including details of extreme and traumatizing disciplinary measures by my ex that I was only able to intercede in or prevent by never leaving the kids alone with him. At the start of the divorce, I filled out paperwork which asked if there had been abuse in the relationship, and I noted yes. No one ever bothered to check. It was just established that when a woman doesn't say anything about abuse until a divorce, that she's making it up in order to win custody. The more loudly she complains, the more likely she is faking, was their philosophy. From the outset, through some Minority Report-esque pre-crime assertion, it was determined that I would alienate the children in the future if they were left in my custody. As an aside, the judge finally admitted on record 6 years later, after the kids were finally living with me again, that he could not see the elements of parental alienation on my case. I had never changed my story. The kids had never changed theirs. The court plainly hadn't bothered to look for the elements until then. Randy Schaffner was the first custody evaluator on my case. My ex paid his retainer and already had his appointments with Randy Schaffner before I had even heard about it. The court told me I had to go along with it since Schaffner had already been paid and my ex had moved to Missouri. Schaffner's 41-page tirade was written as if it had come directly from my ex's mouth, including an allegation of how I supposedly withheld sex during the marriage. Schaffner detailed about a dozen other disparaging untruths about me that he had never bothered to present to me as issues during the evaluation, for which I felt I had solid documented or testimonial contradictions. Schaffner filed his report right before a hearing, and when he discovered that I was challenging his report, he refused to testify on behalf of his report at the hearing. At that same hearing, I exercised my right to a supplemental evaluation, to obtain an evaluation that wasn't paid for by my ex, to help eliminate bias. I chose Marlene Bishop, who unbeknownst to me at the time was a father's rights proponent. For my half of the evaluation of the kids, I say half even though it wasn't half, she spent about 15 minutes at my house, most of which was her searching my phone book to look up and call her next client to say she would be late for her time with them. Then she walked my kids basically across a field to their child care program, and according to their sign-in log, she left there not much more than 10 minutes after she'd left our house. For my ex's generous half of the evaluation, she flew out to Missouri. I later heard from a relative that my ex had been bragging that Marlene had sat next to his commanding officer on the flight and had discussed the case with him openly on the plane. Marlene spent 3 days supposedly observing my ex with the kids, during which time the kids reported either going on outings with her alone or being locked in their room while he spoke with her downstairs. In court at final orders, my ex admitted that he had paid Marlene Bishop to, quote, expedite her report. Not only did my ex paying my evaluator undo the protection of bias, Marlene also lied about her own bias in court, claiming she had never read Randy Schaffner's initial report. The recommendations on Marlene Bishop's custody evaluation report are word for word copied from Randy Schaffner's previous report. Another bias I later discovered was that Marlene was, and may still be, on the payroll of the courts, teaching mandatory court-ordered parenting classes. Once the kids were forced to live with their father, and they kept reporting abuse to me, Marlene Bishop was ordered to do a supplemental evaluation. This was entirely wrong because an evaluator is not supposed to do another report after custody has been determined by the court. The court mitigated my objection by ordering her to only investigate what had happened since final orders. She did no investigation and took her anger for me, calling her a liar for her false testimony, out on my kids, convincing them it was their fault they were living with their dad. Marlene recommended that my visitation with the kids be cut to nothing more than 5 weeks in the summer and a week at Christmas. And the court once again rubber stamped her report. The kids were about 9 and 10.5 years old at the time and started talking about the options of suicide or killing their father to get away from the abuse. When the abuse reports continued to pour in from me via phone calls with the children, Dr. Michael Wilborn was appointed as a parenting coordinator. In that role, all he was supposed to do was offer advice, nothing binding. He claimed to me that this made him powerless to intercede on behalf of the children. Suddenly, I believe after a large payment from my ex, Dr. Wilborn participated in wiretapping with my ex. Dr. Wilborn took wiretapped recordings to the judge on my case ex parte and set an immediate status conference regarding the contents of the recordings, which I had never been given. I countered with a motion to the court objecting to any action coming out of a wiretapping violation or ex parte communication and asking for Dr. Wilborn's recusal. Although a status conference is not an evidentiary hearing, the court set orders unilaterally appointing Wilborn to a position of arbiter on my case, which is unlawful in and of itself, and set new conditions regarding my visitation with the children. I could not afford a lawyer and did not know much about law at the time, so I had no idea that I had grounds for an appeal until it was way too late. Dr. Wilborn asked me in for an appointment in his office immediately after that and asked if I was going to pursue wiretapping charges. I told him that I didn't think it was appropriate for him to ask about or advise me on that. He responded by telling me a story about another mother client of his who had been fighting for custody of her kids who were living in another state, like mine, who had tried to accuse him of wrongdoing. He informed me of how he simply reported to the court that she had mental problems, was a danger to her children, and she never got to see her children again. Despite having so much stacked against it, the children were finally returned to my custody after the kids' local therapist in Virginia, Dr. Cynthia Lease, wrote a report documenting the constant reports of abuse from the kids and her concerns regarding their conflict with their father at my request. Because she was a peer professional to Dr. Wilborn, I knew he had no standing to argue against her recommendation for the kids. The kids were finally granted a reprieve from their torture, and their last 5 years have been a journey to overcome PTSD, depression, and rage. They are 18 and 19 and a half now, and can tell their own stories, but I think they would agree that their rage mostly lies in the fact that their father has never been held accountable for their abuse. It saddens and sickens me not only that my children had security and safety stolen from their childhood, but more so that everyone involved knew or could have known if they'd bothered to ask or listen that the children were getting hurt. They just looked the other way. It wasn't worth their time or care. No children here are safe until someone with power and authority can rip open the corruption in the filthy 4th Judicial District and hold these judges and court-appointed so-called professionals accountable.